Good morning, Your Honor. The first thing I would like to address is the bond act itself. I'd like to step back a minute from the arguments that have been made and look at the requirements of the bond act. There are two different types of requirements. There are bond act requirements for use of bond proceeds. Those are the requirements related to construction of the train system. There are also reporting requirements for the legislature for a funding plan. And it's important to separate those two types of requirements because as it pertains to the first type of requirements, the authority must satisfy those in constructing a high-speed rail system. There are a laundry list of design and performance requirements that must be met. There are a laundry list of financial and cost requirements that must be met. There are construction priority deadlines that must be met. And those requirements must be met before bond proceeds can be dedicated to a high-speed rail project or a portion thereof. There are the funding plan requirements. These are reporting requirements for the legislature. And the plaintiff's complaint, as it is drafted, asserts primarily, but not completely, that the reporting requirements for the legislature were not satisfied. Those requirements were for the legislature. The legislature, as the holder of the purse, wanted more information than it usually gets from an executive agency before being asked to appropriate funds for this project. And therefore, it asked for identification and inclusion of dedicated information, and it asked for certification that information was true and correct. The 5 certifications were made in the funding plan, and there is no requirement for any content of those certifications except that they be made. Notwithstanding, there is a lot of content in the funding plan, and the funding plan incorporates the business plans which outline the authority's planning for the high-speed rail system going forward. So the purpose of the funding plan and the purpose of the requirements was to inform the legislature. After the funding plan was approved and submitted to the legislature, there was lots of discussion and hearing and deliberation about whether there was a reasonable certainty of future funding sources, whether the authority could complete the project as planned, whether they could provide the required environmental certifications before proceeding to construction, whether the usable segment that they had chosen would be ready and usable for operation once completed. And after all of that deliberation, which included input from the Legislative Counsel's office, from the Analyst's office, from the public, from the legislature, the legislature appropriated funds for this project. That was the purpose of the funding plan. It was designed to aid the legislature. It was not designed to create a statutory cause of action for breach of a statutory duty. It just was not. The other...
Why not?
Because it was for the benefit of the legislature.
But
it was reported.
Do you think it makes any difference, or do you think there's any merit to the argument that the voters approved Prop 1A? And as a result of the voters approving Prop 1A, that those funding requirements, or those funding request requirements, needed to be satisfied?
Well, you have to look deep into the law regarding statutory duties to answer that question. And the law, as I understand it, is that when a statutory duty creates a cause of action for the benefit of a certain recipient. So we have to look at who these statutory duties were intended to benefit. And those that were intended to benefit in the Bond Act, the legislature have to be separated from those that were intended to benefit the public, like Toss. And the ones that were intended to benefit the public, like Mr. Toss, were the ones dealing with construction of the train system.
But how do you reach that distinction is what I'm trying to understand.
You look at who the statutory duty was intended to benefit. And in this case, the reporting requirements were intended to benefit the legislature.
How do you reach that conclusion?
Because they are, by looking at the statutory language of the Bond Act, they say things like, 90 days in advance of requesting an appropriation, The authority shall submit to the legislature a funding plan that includes these 10 items of discussion. That's how I reached that conclusion. Now, setting that aside, we have argued that on the merits all of those have been met. But preliminarily, it is important to distinguish between the Bond Act requirements that were instituted on behalf of the public. And those were the requirements that the train system meets certain design requirements, that financial and cost requirements be maintained, construction priority deadlines be instituted, and if there is a violation of those duties run to the public. And I think it is important to separate these two types of statutory duties, particularly in light of the fact that the plaintiff's second amended complaint seems to be primarily geared toward a failure of the funding plan. They believe that the information provided to the legislature was inadequate. And that those requirements are, in our view, not actionable, do not state viable causes of action.
Do you think it makes any difference that in terms of the statutory language, the environmental certifications are only in one of those two?
Are you talking about the two funding plans? Could you restate the question?
Basically, you've got an environment, for the funding request, you've got environmental certifications that are required. For the funding expenditures, before that occurs, you don't have any environmental certifications. Is that significant?
That is significant.
Why?
Because the purpose of the environmental certification to the legislature was so that the legislature would know and be reassured and would understand that the authority was not going to start construction and not going to expend any bond funds before having all environmental clearances in hand.
But then isn't it important then that the past tense aspect of the environmental certification be adhered to?
What's important is that no construction start before the environmental clearances are in hand. That's what's important.
But it doesn't say that.
It says that the authority has all environmental clearances in hand before proceeding to construction. And the authority certified that before proceeding to construction, it would have all of those in hand. And that is the certification. That is substantial compliance with that certification requirement. But notwithstanding that, the law requires that. And that's why it's not a component of the second funding plan. The law requires that there be environmental certifications in hand before proceeding to construction.
One other, I guess, related question to that. You're talking about the ICS having environmental certifications. What about the iOS?
The requirement of the Bond Act is that the project that is for which the funding plan seeks authorization has the environmental certifications, and that is the ICS. There is no requirement in the Bond Act that the entire usable segment have environmental certifications, and that would be practically impossible given the length of the iOS South and the process of obtaining environmental certifications. But if you look at the laundry list of reporting requirements for the legislature, there are some that require an assessment of information or presentation of information in terms of a usable segment and corridor, and there are others that do not. And the environmental certification reporting requirement does not require a certification in the context of a usable segment. It only requires it for the project for which the authority is seeking an appropriation. One last point. Proposition 1A is not about a funding plan. It is about construction. And it is important, as I said earlier, to distinguish between statutory duties related to the construction of a high-speed train system and statutory duties related to presentation of information for the legislature. It is clear from the funding plan mechanism that was set up that the legislature wanted more information, better information than it probably usually gets. And that's why it set up this two-tier funding plan requirement. If you look at the requirements for the second funding plan, as you point out, they are different than the first one, and there, for instance, is much more detailed financial information required. Expert information from financial people about the financial viability of the project required.
But do you think the authority could have just simply not complied with the funding request requirements then?
No, I think the authority had a duty to submit the funding plan, and it did that. And it had a duty to provide the information requested in the statute, and it did that. Plaintiff's complaint is about the quality of the information. They don't think it satisfies the requirement, but that was a decision for the legislature to decide, and it balanced the risks. It decided that it understood that there was no committed funding in place to build the entire iOS. There was endless discussion about that. In the part of the funding plan that identifies, in which it was asked to identify known and foreseeable risks, funding is one of those risks identified. So after all of that, the legislature decided to appropriate funds for the project, and that is the purpose of a funding plan. It does not create a viable cause of action on behalf of a landowner like Mr. Toss or a citizen or a taxpayer. The next thing I'd like to discuss is the second amended complaint itself. There are 10 writ claims in there, and they are documented in our opposition. And for every one of those 10 claims, plaintiff seeks a writ of mandate. They have only chosen to argue about 2 certifications in their opening brief and their reply brief. Therefore, it is our contention that their remaining claims for writs of mandate should be denied because a judgment should be entered for defendants because they were not argued and in this proceeding.
But when we talked about essentially the mechanism by which we would proceed, we talked about dealing with the purely legal issues initially, and then going to the factual legal or factual questions at a subsequent point in time.
Well, Your Honor, that is not my recollection of what we discussed. My recollection is that we discussed handling the writs of mandate in the second amended complaint in this proceeding, which were largely based on legal issues, and I think that's pretty much still the case. And then we would see what was left with respect to any other declaratory relief claims that were asserted in the complaint. That is my recollection. And there are 10 writ claims. There are 10 writ claims, and only 2 are addressed here. Plaintiffs are, of course, entitled to pursue their writ claims or abandon them. They're entitled to pursue them by declaratory relief if they think that's the proper way to do it, or abandon them. But as of today, in connection with this proceeding, which was according to the stipulation that we entered into setting the hearing date and the briefing schedule related to plaintiff's writs of mandate, 8 of those are basically unsupported by a memorandum at this point in time. That issue dovetails into whether or not declaratory relief, which is where the plaintiffs want to go after this proceeding, is appropriate to challenge specific public agency decisions. The second amended complaint challenges the funding plan in 2 different ways. It challenges the reporting requirements as having been unsatisfactorily met, and it also attacks some of the planning decisions that were incorporated into that funding plan. Declaratory relief is never appropriate to review a specific agency of a specific decision of a public agency. That is State versus Superior Court, which is cited in our objections at 12 Cal 3rd 237 at page 249. Furthermore, it is not possible to join, as plaintiffs have done, a declaratory relief claim with mandamus claims to avoid the limitations on judicial review of quasi-legislative agency decisions, which is what they have done. They want to try quasi-legislative agency decisions in a civil trial by honor to the evidence, standard of proof, and that is not permitted. And they can't do it by simply joining a declaratory relief action with a mandamus claim, because public agency decisions can only be reviewed by mandamus. That case is Gilbert versus Regents of UC. It is not cited in our papers, unfortunately. 1979, 93 Cal App 3rd 233 at page 244. Plaintiffs' claims in this case are starting to shift from what they are in the second amendment complaint. As Mr. Flashman said, it is, or he intimated, it is possible to challenge the constitutionality of a state statute by declaratory relief. That theoretically is authorized. But there is no claim in this lawsuit that the authority's interpretation of Prop 1A and its planning decisions violate the California Constitution. There is no mention of the words California Constitution in the Second Amendment complaint. There's no reference to Article 16, Section 1 of the California Constitution, which is the basis of all of these cases that plaintiffs have cited in their opening and reply papers and have referred to here at oral argument. Furthermore, even if there was a claim that the intended use of the bond proceeds substantially differed from the object of the bond measure, I don't see how that kind of claim could ever be sustained. The object of the bond measure here was to construct the train system, and the funding plan and its proposal to start construction of the first high-speed segment with a smaller segment in the Central Valley is perfectly consistent with the object of the Bond Act, which is to construct a high-speed train system.
Mr. Flashman's argued, though, that in part the object of the Bond Act was to ensure that, in fact, you didn't end up with a stranded asset. Your thoughts on that?
Part of the funding plan reporting requirements were for the legislature were to ensure that there would be no stranded asset. And to ensure against that, in the funding plan there is discussion of whether the first part of it, the ICS, can be used for conventional passenger rail travel. In the unlikely event that there is never any future funding sources for the rest of the iOS South. And that was the stopgap. That was the mechanism by which the authority ensured that there would be no stranded asset out there. It can be used for conventional passenger rail travel if that becomes necessary in the future. Mr. Flashman also stated that the court is authorized to find the appropriation invalid by writ of mandate if the funding plan that requested the appropriation failed to, in plaintiff's view, satisfy the reporting requirements by not providing enough information or information with reasonable certainty, or there were lots of other standards that were thrown out for the court. A petition for writ of mandate can never be used to attack a legislative appropriation directly.
I didn't hear him actually argue that. I heard him argue that, in fact, the court could make a debt relief determination that, in fact, the legislature's action was ultra virus. So a little bit of a different argument, I think, is what you said.
I heard that the appropriation itself could be held invalid. We would agree that if the underlying program that is authorized by the appropriation was invalid, that is an issue that the court can deal with, but not the appropriation itself. And there's case law to support that. The last thing I'd like to address are these two certifications. And once again, there were more than two certifications that were plaintiffs sought writs of mandate in their Second Amendment complaint. They also alleged that the certification regarding whether an operating subsidy would be required was inadequate in their view. They already argued that the certification about whether the segment would be ready for high-speed rail service was also inadequate. They chose to only argue about two of them. One dealt with the environmental clearance, and the second dealt with whether the project could be completed as planned. But that is linked to their argument that the funding plan reporting requirement relating to identification of funding sources was inadequate. We would submit that the language of the reporting requirement is that the authority identify all known and all known and, what's the word, and expected, I'm not sure exactly what the word was, sources of federal funding. They did that. They identified funding in place for the ICS, and they identified future possible sources of funding. And that is full and complete satisfaction of the funding plan reporting requirements. Plaintiffs believe that it's inadequate, but that was a decision for the legislature. And that is yet another clue that that the funding plan was mainly for the benefit of the legislature. But if you look at the words of the statutory requirements in the Act, it says include and identify all sources of funds to be invested. And those are included and identified in the funding plan and in the incorporated business plans. Furthermore, all the discussion about the content of these certifications is not supported by a review of the Bond Act. There is no requirement of a certification regarding technical feasibility, no requirement of certification regarding financial feasibility. The certifications don't require any content. They require that they be made. Now, I understand, and the authority understands that if they made certifications without any content, then they would be at risk of not getting an appropriation from the legislature, and that's why the funding plan is detailed and it incorporates all of its planning that is set forth in the business plans.
Well, let me follow up on that. Let's assume that happened, that the funding request didn't have sufficient material, and the legislature still appropriated the money. What happens?
The project approved by the appropriation would be constructed. I mean,
even though the funding request was deficient.
If the funding, the
My
requirement.
premise is this, just for the sake of the example.
Okay.
The funding request is deficient. The legislature receives it and yet still appropriates the money. What happens?
The legislature assessed that it was deficient. The legislature looked at it and said, we would like more, but this is what we got, and it made its decision. Those are political decisions that I can't comment on, but all that the statute requires, all that the Bond Act requires is that the sources of all funds to be invested in the corridor be identified. And here it decided that the identification of known and future sources of funding was sufficient for the state to take the risk to invest an initial sum of money in construction of the ICS. All of this assessment of risk is for the legislature. And presumably taking this to the nth degree, the authority could have said, but it didn't, there are no sources of funds to be invested in the corridor, and we're asking you to appropriate funds. It could have done that. I mean, but it's up to the legislature to decide what is sufficient and what is not sufficient, and what risk it's willing to take.
Do you think the O'Farrell line of cases provides any kind of restriction on the legislative action?
In some sense, it's as I said, the Prop 20 is not about a funding plan. It's about the object for which the bond funds were appropriate were passed, and that is construction of a high-speed train system. And to the extent that the authority is proposing and the legislature is appropriating money to build a high-speed train system that is not consistent with the requirements for use of those funds, then yes, the O'Farrell line of cases is relevant. But once again, that claim is not made in the second amended complaint. And the funding plan sought an appropriation to build the first part of the iOS South. That is completely consistent with the object of the Bond Act, which was to construct a high-speed rail system. We are now talking about whether there was about funding plan reporting requirements to the legislature. And as I have stated already, those were for the benefit of the legislature, and in any event, we argued in our pleadings, the authority completely complied with those. There is an identification of funding sources. There is no requirement of a certain level of certainty, reasonableness associated with those. There has to be an identification of sources of funding, and they are identified.
Do you think the O'Farrell line of cases at least provides any support for the issue that, in fact, those conditions were something that had to be satisfied?
But who is the judge of satisfaction in this case? It has to be the legislature. It has to be the legislature because the funding plan is a request to the legislature for money.
But isn't that the role of the courts?
The role of the courts is to determine whether the Bond Act requirements for use of bond proceeds comply with the law. And as I mentioned, there are a laundry list of requirements, design and performance requirements, financial requirements, construction priority requirements. The authority has to build a project that complies with all of those.
But let me ask it this way, and I'll just be very specific. One of the requirements for the funding request was an environmental certification. The environmental certification requirement appears in the past tense. The environmental certification that was provided appears in the future tense. Is that satisfaction?
It was up to. It is satisfaction if you look at the purpose of that reporting requirement. And the purpose of that reporting requirement was to ensure that there was no attempt by the authority to circumvent CEQA requirements. And the certification states precisely that before expending any bond money before proceeding to construction, it will have those in place. So if that is the purpose of the certification, then the certification was met. Secondly,
so before you leave that, the language in the statute is past tense. The certification is future tense. So just by its very nature, satisfaction can't have occurred.
There is not a precise match between the certification met and the certification made and the certification requirement. However, there is certainly substantial compliance if you consider the purpose of that certification. And that satisfies the requirement that the certification requirement in and of itself. However, the legislature saw that the certification was a will have certification versus have certification, and it decided to appropriate funds.
But that's why I asked about the O'Farrell line of cases. Does it apply in such a situation?
It does not apply because the O'Farrell line of cases relates to whether or not there's been substantial compliance with the object of the Bond Act. And the object of the Bond Act is construction of a high-speed train system. The cases, especially the two older cases that the plaintiffs spent a lot of time discussing, deal with bond acts that dedicated money to build, in one case 30 bridges, and in another case a mile or so of road. And the legislature was proposing appropriations or plans or making decisions that didn't comply with those. In one case, they took money that was dedicated to Bridge A and decided to use it for Bridge D that wasn't among the bridges identified in the Bond Act. So there was a substantial differentiation between what was proposed and what was authorized. Here, what's authorized, the object, and I think the language of the Constitution and the language of the cases is always asked, what is the object of the Bond Act? And the object here is the construction of a train system, and the funding plan proposes to construct the first part of that train system. So the O'Farrell cases do not state a basis for finding a constitutional violation in this case.
All right, anything further?
One last point relating to the O'Farrell line of cases. If you look at the O'Farrell line of cases, there is no requirement for 100% precision between the intended uses of bond proceeds and the proposed uses. The language of those cases is about substantial compliance, significant differences. And the facts are always about proposals to use bond proceeds for projects that are not authorized by the by the Bond Act. In this case, the Bond Act was not about a funding plan. It was about constructing a high-speed rail system. And therefore, the plaintiff's writ should be denied. The funding plan, I made all the identifications and certifications that it was required to do. And the project complies with all the statutory requirements for development of a train system. It meets all of the financial criteria. It meets the construction priority requirements. It meets, to the extent possible, at this very early stage. It was offered with the understanding that it could meet, all design and performance requirements.
So, Flashman, any reply you'd like to make?
Yes, Your Honor. A number. Let me start with the issue about what we're dealing with today and what for the future. And as you're aware, the complaint is both for writ mandamus. It's also for declaratory relief. It's also for injunctive relief under Code of Civil Procedure 526A. And really, when you read through the complaint, of course, each of the causes of action incorporates everything prior to it by reference. So essentially, all of those are rolled together into each of the issues in the complaint. Each of the causes of action includes all three. Now, we are only prosecuting today two of those mandamus claims because, frankly, those are the only ones we think right now are right. The complaint also raised issues around the second funding plan that hasn't been issued yet, where basically they were made essentially towards the future and sort of saying, well, if these are right at the time we bring them to trial, we'll bring them to trial. They aren't, and so we're not. In terms of the 526A action, we think all of those issues are going to be addressed in the 526A action. So to the fact that we're not addressing them in the mandamus causes of action, it simply says, yes, we're not seeking mandamus relief on those particular. And if you want to say they're abandoned, I suppose you could say they're abandoned because they're not right, and they would be dismissed if we didn't abandon them because they're not right. So we're not going to try and try a claim that simply isn't going to go anywhere. But that doesn't say that those particular issues are dead. It just says that they're not right for adjudication as mandamus claims. And we'll be coming back to them as you pointed out. There's a whole question of, well, where we go from here once we've dealt with the mandamus claims, and that's to be decided when we have our case management process. So I suppose we'll wait to hear what you say about these mandamus claims, and then we'll talk about what happens next. But certainly premature to be starting to talk about entering a judgment of any sort. In terms of the funding plan issues, I think there's a good question that you asked, and that was, why was it put on the ballot? And it's important to realize that the legislature passed a Bond Act that was much larger than what was put on the ballot. Not everything that was in the Bond Act was put on the ballot. And if the only purpose in the funding plan provisions was to provide information to the legislature, there would have been no reason to put it on the ballot. Essentially, they would be, by that part of the statute, they would be essentially telling the authority, we want this information, you tell us what we want, and then we'll be satisfied. But they didn't. They put it on the ballot. And why did they put it on the ballot? Because they felt the voters needed to know about it. And why did the voters need to know about it? Because it was part of the provisions that were intended to provide the voters with assurance that this was going to be done very responsibly. These were protections for the voters as taxpayers, because the voters were approving a bond measure that was going to be issuing bonds that they were going to have to pay for. The taxpayers were going to have to pay for. And these were assurances to the voters that, don't worry, this is all going to be responsibly done because we're putting in these requirements. And these requirements need to be complied with, and you don't have to worry about things being done improperly because all of these requirements are mandatory. And let me quote from the respondent's opposition brief. To allow the legislature and state officials the opportunity to provide financial oversight, not just the legislature and state officials. The Bond Act imposed limits on the authority's ability both to request an appropriation of state funds from the legislature and to spend funds previously appropriated. So essentially what they've admitted here is that the Bond Act restricted when the authority could go to the legislature for funds. And that was precisely the purpose of the funding plan, was the restriction. Basically what the legislature told the voters and the authority was, here's the funding plan. You need to complete this funding plan. It has to include the elements that we're identifying to be included, and you have to complete it successfully before you can ask for an appropriation. And I think the answer to the question, well, what's the remedy, is if they didn't successfully complete the funding plan, they were not entitled to ask for an appropriation. And you asked also about, well, what's the funding plan? What about these requirements in the funding plan? And respondents' answer is, oh, well, it was up to the legislature to determine whether it accepted it or not. So what if the authority had simply submitted a funding plan that consisted of 7 words? Trust us, give us lots of money. It wouldn't have satisfied any of the funding plan requirements in terms of certification. Would the legislature be allowed to go ahead and say, oh, okay, here's $10 billion, because you're asked nicely? I don't think so. I think that would have subverted the whole purpose of putting the funding plan provisions not just into the Bond Act that was approved by the legislature, but into the Bond Act that was approved by the voters. When they put it before the voters, they were essentially making a promise to the voters. They were promising that this is how it's going to be handled. And the voters approved the Bond Act based in part on those promises. And those promises are part of the contract. And I think they're just as binding as any other contract provision. And the authority cannot now say, oh, well, that wasn't intended for the voters. If they put it on the ballot, it was intended for the voters. If they didn't want it included on the ballot, if they didn't want the voters to be able to rely on it, they shouldn't have put it on the ballot. You actually also raised another interesting and important point about the environmental certification. You pointed out that whereas most of the provisions in the first funding plan carried forward to the second funding plan, the environmental certification did not. And the question is, why not? And I think the answer is because the way the environmental certification requirement was phrased in the past tense, there would be no reason to put in the second plan, because if everything had already been certified, had been satisfied, all of the clearance had been obtained before the first funding plan, why was there any reason to ask anything more in the second funding plan? Everything's done. Well, by the authority's interpretation, everything wasn't done. And if that had been the intent, then there would have been a requirement in the second funding plan. The other point that I think, again, is raised by that question is, what's the purpose of that requirement? Now, the authority argues that they're required to have all of the environmental clearances completed before they go to construction. That's law regardless of Prop 1A. So the question is, well, if that's already required, why did they put it in Prop 1A? That language would have been superfluous. There would have been no reason to put it in the funding plan, to put it in the ballot measure. That can't have been the case, because again, as we know, when you're interpreting statutes, you try and give meaning to every word in the statute. If all you're doing in this provision is just doing what the law already requires, that provision would be superfluous. It has to mean something more than that. And I think what it has to mean is the fact that it's requiring it not when you go to construction, but when you certify the funding plan. When you say, we want funds, at that point, basically what the voters were said you can demand, and basically is demanded, is at that point you have to say, we're ready, we've got all of our clearances done. You don't have to worry about environmental clearances stalling things, because we're done. And the certification that the authority made doesn't satisfy that. It doesn't give that assurance that you don't have to worry anymore about the environmental clearances because they're all done. They weren't all done. And that didn't satisfy the requirement of the funding plan, didn't satisfy the promise to the voters. And essentially, their interpretation would make the promise an empty promise, which again is something that you don't do in interpreting the statute. One other thing, and that has to do, and it really sort of ties in with this whole question, both of the funding and the environmental clearances, and that is, what was the purpose of saying you need to know where the money is going to come from? You need to know you can complete it successfully. And there is a separate provision, and that was provision D under that same set of requirements. It says the plan shall, and by the way, it says the plan shall include, identify, or certify to all of the following. Now, it's include, identify, or certify. They're in the alternative, and presumably that means as appropriate. And subsection D under that is that the plan shall include, identify, or certify the sources of all funds to be invested in the corridor or usable segment thereof, and the anticipated time of receipt of those funds based on expected commitments, authorizations, agreements, allocations, or other means. So now, again, it's left unclear whether that's just identification or whether it's also a certification. But it's clearly asking the authority in the funding plan to say, show us the money. Or at least show us where the money's going to come from. Maybe you don't have it all in hand, but show us what are the commitments, authorizations, agreements, allocations, or other means that you know you've got money that's going to be there. And again, I think that ties in with the provision that subsection G says that the corridor or usable segment thereof can be completed. You take those two together and it's basically saying you need to show us where is the money going to come from. And again, the funding plan really acknowledges they don't know. You know, it says, well, we've got funds here, we've got funds here, we could maybe have funds there, we possibly could get some funds here, we'll get some funds in the future there, but we know we won't get them now. That's not what the funding plan required. And they didn't satisfy that requirement. And the reason for having that requirement is precisely so you don't end up with a stranded asset. And one of the things that the authority in their revised expenditure plan, 2012 revised expenditure plan of April 2012, they said, well, if we don't complete this, we will essentially convert what we built into an Amtrak segment and hand it over to Amtrak, and Amtrak can use it for conventional rail. And the argument they make is, well, you see, we're not going to have a stranded asset. It will be useful. It won't be high-speed rail, it will be useful. But the bond funds are for high-speed rail. They're not to build track for Amtrak. They're to build a high-speed rail system. If you built that initial segment, initial construction segment, and you couldn't go further, and you ended up handing it over to Amtrak, you would have violated the terms of the bond, because you would not have built a high-speed rail system. And the purpose of these requirements in the funding plan was to make sure that didn't happen. And by violating those purposes, it's violating the Bond Act itself, because it's not assuring the voters, it's not doing what the Bond Act required, and you could end up with something that was in fact in violation. It's as if, in the O'Farrell case, the Board of Supervisors there said, okay, start building and go as far as you can. And if you don't complete it, well, you've done what you could. I don't think that would have been any more in compliance with the Bond Act than basically setting up a contract that allowed them to build 2 miles instead of the 4 that had been promised. If you're complying with the Bond Act, you have to comply with it. If you're starting off building and you can't complete, or you don't know if you can complete what you set out to do, you're not complying. And I think that's what's happening here.
Ms. Eno?
May I briefly respond? The example, trust us and give us lots of money as the main reporting requirement, I guess hypothetically could be the basis of a funding plan. But there, in the real world, there would be no reasonable likelihood at all. There would be no likelihood at all that the authority would get an appropriation if it made a trust us and give us all the money statement in a funding plan. This is about providing more information, a high quality of information for the legislature to consider in making its decisions. Furthermore, there was no trust us and give us all the money we have certification. All the reporting requirements were met. We are talking about whether the plaintiffs are satisfied with them or not. There was an identification of sources of all known and future funding in that funding plan. There was the identification of sources in hand to complete the ICS completely, and there were known and potential sources also identified in both the draft plan and business plan and the revised business plan. Those are not insignificant. There was state funding from the Bond Act proceeds. The Bond Act is $9 billion, and only 3 or so billion was appropriated. There is a considerable amount of money left in of bond proceeds that are left. They identified local funding sources. They stated that federal funds have historically provided 50 to 80% of funding for major transportation projects. They said an important source of future revenue would be local and private revenues from a variety of planned identified sources in the business plan. They said that once the IOS was operable, the authority would be able to attract private capital to leverage public funds to complete construction of future sections of the train. Those were the identified funding sources. They included funding in place and potential future funding. And once again, it was up to the legislature to decide whether or not that was sufficient. There is no requirement in the Bond Act that there be funding in place to construct the IOS South. There's no requirement that there be funding with a reasonable level of certainty or the other standards that plaintiffs have offered. It is an identification of known and future potential sources of funding, and that is made in the funding plan as incorporated by information in the 2 business plans. The environmental certification doesn't carry forward into the second funding plan because it's the law. What was at issue was a certification that the authority would comply with CEQA before commencing construction. That was the legislature's concern. It is an unreasonable interpretation of the Bond Act to say that it was the reason for that environmental certification was to avoid delay. The way the funding plan mechanism is set up is that there are 2 funding plans. So even after an appropriation, there still has to be a process of approval of a second funding plan with a number of expert reports and presentation of that second funding plan to the director of the Department of Finance, who then is given 60 days under the Bond Act to decide whether or not to authorize spending of bond proceeds. So delay could not have been the reason, because the process is in the second funding plan process itself causes delay. It was about ensuring that there would be no attempt by the authority to get around CEQA requirements. The last thing I want to say is that, and it addresses this issue of a stranded project. There is no intent or evidence in the funding plan that the authority is proposing to build a conventional rail system here. The ICS is the first part of the IOS South, and the purpose is to build a high-speed rail system. The Bond Act itself authorizes use of parts of that system for conventional rail as necessary, and that is a way to avoid a stranded asset, and that was one of the issues that the legislature discussed at length in its hearings before appropriating funds. But this is not about building a conventional rail system. This is about building a high-speed rail system. And the fact that while that system is being developed, it could be used for conventional rail and have some independent utility is just an added benefit, and that is authorized by the authorized by the Bond Act. But the object of the Bond Act and the funding and the object of the funding plan, which are perfectly in sync, is to construct the first segment of high-speed rail in California.
All right, any other council want to add something?
Your Honor, I'm Ray Carlson on behalf of the amicus, Kings County Water District. I just had one quick remark. Our amicus brief was largely directed to the financial issues that have been discussed here. And I thought I had a thought occurred to me that maybe we could put this in perspective by looking at the Panama Canal. Panama Canal was paid with money, mainly gold and silver, as it was built. This project is going to be paid with debt, and that debt is going to have to be repaid by the taxpayers. And any shortfall in the ability to pay is going to impact taxpayers and public entities, small public entities throughout California. So my short remark is that Proposition 1A was designed to protect the people who are going to pay back this debt from the potential adverse consequences. Therefore, Proposition 1A should be applied, if anything, leaning toward the protection of the public. Thank you.
Anyone else?
Your Honor, I'm Tom Phelan. I'm the Chief Counsel for the High Speed Rail Authority. And I'd like to make the suggestion that you read the Legislative Council's legal opinion that was presented to the legislature before the appropriation. I think it's quite thorough in the analysis of the Prop 1A bond initiative, and I think it's very telling in the communication that was the legislature received before they appropriated, and really gives, I think, confidence that the High Speed Rail Authority had complied with the Proposition 1A requirements. Okay.
Your Honor, a couple points. On this last point of the Legislative Council's opinion, of course, the respondents mention it. They don't certainly place a lot of reliance on it, and I don't think much reliance was called for. Again, using the Yamaha standard, this opinion that was issued long after the Bond Act was passed by the legislature has very little validity, or very little of the bases which Yamaha identified as saying this is something that requires deference. In fact, there was also analysis done by the Legislative Analyst Office, which runs in very much the opposite direction of that of the Legislative Counsel's Office report. So you've got two different opinions of, well, what are you saying? And one says it looks good, and the other one says it doesn't look good at all. I don't think you give much credence to either of them. You go back to the statute itself and ask, what does the statute mean? And essentially, why was this placed before the voters? One other point I want to just briefly mention, which is that was the idea that we had to reference the unconstitutionality of the legislature's action. I think counsel is attempting to bring us back to the time period when pleadings had to be done with specific identification of the specific cause of action. And if you didn't identify exactly the right cause of action in the right way, with all of the details, your cause of action was invalid. I think we've gone now in California to fact pleading, and I think the facts that we have pled are sufficient to support the causes of action and the relief we're asking for. And I don't, if necessary, we would amend the complaint if we need to, but frankly, I don't think it's needed.
All right, anything else by council?
Nothing for you.
Submitted.
Submitted tomorrow.
Thank you all.
Thank you, Ron.
Thank you.